on and off again, Tshwane Mayor Murunwa Makwarela could now face fraud charges. This after submitting an insolvency rehabilitation certificate, which was discovered to be fake. The drama surrounding the mayoral chain in Tshwane has definitely taken another turn. So what are the legal implications as he now may face both fraud and perjury charges? Well, let's discuss this with Mpumelelo Zikalala, a legal analyst from Zikalala Attorneys. Mpumelelo, good morning and thank you very much for your time. Mr. Makwarela's matter has implications on both the political and legal front. For the most part, everyone has been focused on the political implications, which were immediate. He's since left council, he's gone. But the legal are now to follow. Just talk us firstly through the seriousness of an offence of falsifying a court order.
It's a very serious offence, especially because even the courts have said and issued out various statements saying that members of the public beware. There are individuals that are falsifying court orders that have done very serious implications. But from a legal point of view, we then have three offences that can take place. Firstly, as I've stated, fraud. Secondly, perjury. Another one, forgery and uttering, which carry a very heavy sentence when it comes to the perpetrator or the way in which these particular matters must be dealt. But it does not end there. There are also civil proceedings because the municipality can then come back and say, you know, Mr. Speaker, you've caused us a lot of amount of money that we have lost due to the number of meetings that we've held, due to the court litigation that you are now going to face, a possible review of some of the actions and decisions that you have taken, being in a position that you shouldn't have been in had you disclosed all this vital information when you are asked to do so. So there's going to be a number of legal challenges which are going to come in, both from a civil proceedings type of view and also from criminal proceedings, which can land him up in jail or be given a fine.
But insofar as the council is concerned, attempting to recoup some of those monies paid to him over the years, I mean, how easy would it be? Because if he's an insolvent that has not been rehabilitated, one assumes they'd have to get in the line of other creditors.
Definitely, they'll have to do so. But let's also remember that there might be things like your pension, with pension that they can go and say, freeze this amount up until our matters have been done and dusted with, because we may want to recover or refuse to pay him if it was not eligible or that particular benefit or that financial benefit was not due to him or not to be given to him in the first place. So it might be a bit easier for the municipality in terms of saying we are going to withhold whatever monies that we have. For example, this month's salary can even be withheld up until all these particular matters are there. So yes, they would fall in the line of other creditors that are there and deal with the trustees and the individuals which are entrusted to make sure that he's a rehabilitated individual. But at least they have close resources that they can be able to cut off and at least try and recoup some, if not all, the monies which are going to be owed to him from the municipality.
And then to the rehabilitation process itself. We heard how there was an attempt by Mr. Makwarela to bring an urgent rehabilitation application, something that we heard is unheard of. Perhaps just take us through the stages of the rehabilitation process and whether, if you're somebody that now earns some sort of a salary, would you then have to constantly be paying towards those creditors?
Let's remember, we have to firstly look at how you got to be an insolvent individual in the first, meaning that your liabilities exceed your assets. You can't really pay back the monies that you've taken, the people that you owe. So the first step is, let's deal with the people that you owe. They may not get the full amount or partial amount to be given to them, but try and pay them off. But once the process has been done and dusted, then the individuals, which are your trustee, will then go back and write to the master and say, yes, Mr. So-and-so has been able to pay their debts. This is how the payment plan was done. This is how the disclosures were done. He was honest to us when he was disclosing all those financial obligations and the assets that he had. Really, his financial situation has improved for the better. He has learned his lesson. And we're of the opinion that he can go back and be a person that can be able to manage their own finances. Now, either through the passage of time, which is plus minus a minimum of 4 years, if I'm not mistaken, or if it has been done in a much quicker time, then you can write to the master and say, we've been able to do our job of rehabilitating this particular individual at a much faster pace. But that's not the decision of the master only. Even the courts have got to come in, the judges in this case, and say, let's assess this particular assessment. Let's look at the manner in which that particular individual has behaved. Let's look at the manner in which payment has been done. Let's get confirmation from those creditors that they have been paid. So after the process, only then you can then say you are now rehabilitated. As the name says, it simply says you were once in financial trouble, you have learned your lesson, paid your dues, you are in a situation where you can do better. and the financial situation has improved, and everyone is happy in terms of who has been owing at the time in which the particular insolvency application was being made.
Then to this other aspect, in no way do we attempt to absolve the former mayor of any wrongdoing. But when we talk about attorney-client privilege, where one would still be looking for an ideal attorney, which you guys would refer to as forum shopping, one can disclose incriminating information. Is that lawyer, if not briefed, allowed to share such information that would have been disclosed? And we asked this because last week we spoke to Tshwane Mulder, and Mr. Mulder indicated and quoted the particular law firm that assisted him throughout the forum shopping. I believe then he went on to disclose exactly what had happened, but he never stayed with that attorney and went to another. So is it permissible for an attorney to then share with any other person what would have been disclosed by a potential client?
Not at all, and that you've been ordered by the court to do so. The client attorney privilege prevents you from doing so. The principles in which we live by, or the code of conduct in which the Legal Practice Act then prescribes, simply say that whatever that has been disclosed to you by a potential client or even a client cannot be disclosed to anyone unless there's a specific order that orders you to do such. And it goes back to your basic business principles. You want to protect the business or the private business of any individual who's going to come through your offices. It is not your business to go and disclose the things which have been discussed with you in confidence. So you should keep them a secret up until called upon to do so by court. If no court has called you to do so, you are under no obligation. And in fact, the obligation is for you to protect that information so that it does not go out, and make sure you protect the potential client that you could have had. So that particular lawyer, there may be instances of misconduct that may have taken place. If you closely look at the Legal Practice Act, I'm sure there are some type of transgressions that may have occurred if it is that they did disclose this information to third parties without the permission of their client or potential client being obtained first.
Because the information might not seem so incriminating, but it was the intention to bring an urgent rehabilitation application. So just that aspect. For any other person, it would then indicate that you are not rehabilitated. Would it not?
Yes, it would. And it forms part and parcel of the acknowledgement that you are in deep trouble when it comes to the rehabilitation. You understand the problem that you are in, and you understand that at the end of the day, once you've submitted that particular certificate, you knew that it was forged. So it brings up all the other charges that we spoke about earlier, which is your fraud, forgery and uttering, and also perjury. So it goes directly into those particular cases. In fact, the investigating officer will then go back and say, let me even go and try and speak with this particular attorney or subpoena them, or get the court to pierce the veil between attorney and client privilege, so that you can be able to get this information. It's going to assist us with the intention of the above criminal common law crimes that you have stated earlier, so that you get a much more better conviction. Another thing that's going to be looked at by the court during the sentencing stage is going to say, well, you knew what you were doing, you understood the implications of such. Your particular intention was to defraud the municipality and mislead individuals, which speaks directly to this common law principles of crime. So we should give you the maximum punishment, especially because we are not dealing with an ordinary person here. We are dealing with a person who has presented themselves as a people representative, a person who has been in the council for a number of times, fully understands the importance of being a well-respected and a person of integrity due to the position that you hold. So if you engage in such, then what are you teaching the community? So let's teach the community through you that if you engage in activities such as these ones, this is the maximum punishment that you are going to get. And the courts may even come back and say, we're not going to fine you, we want to send you to jail, so that you have a full and better understanding, and you send a clear message that if you engage in instances of fraud, forgery, uttering, or even perjury, this is the type of sentence that you are going to get.
Mpumelelo, thank you very much for your time this morning. That was legal analyst Mpumelelo Zikalala from Zikalala Attorneys.